and today we're looking at the answerability of chief and council. So when there's chief and council misconduct that occurs, and somebody either in community or at the Witset administration or another Witset chief or councillor identifies that somebody on council has engaged in misconduct, the next question is what happens with that allegation? So who brings that out? Who's allowed to bring allegations about that stuff forward? What is the process that gets followed, etc.? And so today when we talk about that, my thoughts were, first, I will share with everybody how things work under the Indian Act and under the First Nations Election Act when it comes to a removal from council. And under those two federal laws, there is no process for holding chief and council accountable other than removing them from office. So it is a very restrictive process. I will also talk about two different ways that individuals can hold chief and council accountable for their actions under the common law. So basically by bringing them through court and filing a private private action against them in court. So basically, I guess if you think of suing somebody through private laws in a court system, that's what that would be about. And then I'll also talk about how things work in the province and what other First Nations have in their laws. One of the First Nation laws that I'm going to share information about is one that we worked on with another First Nation, and then the other First Nation did not approve it because they did not have enough people participating in the process to treat it as an approved ratification vote. And another First Nation, not one that we worked with at Kinna Law, used the law that we drafted for the First Nation we worked with as a template and adopted most of the process. So that will be that when we get there, it'll be an example of what one First Nation intended to do that we drafted for them, but another First Nation ended up actually doing it. And then talking a bit about remedies. So not just the process of who makes decisions about whether misconduct occurred and how do those decisions get made, but what happens if there is a finding that misconduct occurred? What are the different options for making things right or for there being some sort of a remedy for that misconduct? And one of the things that we'll see when we look especially at how other First Nations laws operate is that there's kind of a blend of approaches that First Nations take. And one approach is to investigate the misconduct, and the other approach is to adjudicate it. So to have people who are in dispute about whether misconduct occurred go before an independent decision maker called an adjudicator and have that person act kind of like a judge in a court process to make the decision. So I'll talk a bit about the difference between an investigative process and an adjudicative process. Both have kind of pros and cons to them in terms of considering them as an option for dealing with misconduct of chief and council members. Another thing that's not on this kind of mini agenda here is that I will look as well and talk about some of the things I identified in Wet'suwet'en literature about how things occur when there's some sort of misconduct that's happened by a leadership. So we'll move now on to the Indian Act and the First Nations Election Act and what they say. So under the Indian Act, their position is vacant if a person dies, resigns, or is convicted of an indictable offense. That's an automatic vacancy that occurs if any of these three things happen. We talked in a past meeting about an indictable offense being a criminal offense that's on the very severe side of types of offenses. So this would include things like murder, robbery, sexual assault, the very serious offenses that come with the highest of punishments. In addition to this, the Indian Act says that the minister can remove a person if they miss 3 council meetings without council authorization. So the minister is the decision maker under the Indian Act about removing a council member. Under the First Nations Election Act, if the Council of Witset were to opt into that legislation by passing a BCR saying we are going to be under the First Nations Election Act instead of the Indian Act. Again, a position would be on chief and council would be considered vacant if a person were to die, resign, or be convicted of an indictable offense. However, in the First Nations Election Act, that person would also have to be sentenced to more than 30 days in jail in order for that position to be considered vacant. There is no rule in the First Nations Election Act that says that the minister can remove somebody from missing council meetings. So there's not a heck of a lot in the Indian Act or First Nations Election Act that talks about or addresses issues of chief and council accountability. Now, outside of the Indian Act and First Nations Election Act, there are ways for individuals to bring private legal cases against a chief or council member in their capacities as public officials. So that's in the chief or councilor's capacity as a public official. So there's ways that individual band members could hold them accountable for their actions as chiefs and councilors. And the two different types of legal cases that can be brought forward are for misfeasance of public office and for breaches of fiduciary duty. No matter what Witset decides to do with regard to its election law, these options for people in the community to bring a legal case against a chief or councilor will continue to be there. So even if the election law says nothing about chief or councilor accountability rules, even if it says nothing about how to hold a chief or councilor accountable, these two types of private legal cases are still available to members to use. So in the first case, being misfeasance in public office, I've listed a couple of cases here that have gone as high as the Supreme Court of Canada to define what a misfeasance in public office is. So what would an individual person have to prove in order to be successful bringing a case against a chief or councilor for misfeasance in public office? And basically what that person would need to do is they would need to prove first that the person who they're bringing the case against is a public officer, so that they are a chief or councilor. And then they must show that the chief or councilor's conduct involved the exercise of power as a public officer or their exercise of a public function. So at the time of the conduct, the power they were exercising was a power that they have because they are a chief or councilor, or they were exercising some public function or public responsibility as a chief or councilor. And then they would need to show that the public officer, so the chief or councilor, engaged in a certain type of conduct. And they would need, so for that, they would need to show that the conduct of the chief or councilor was deliberate and that it was unlawful in the exercise of their public function. They must have deliberately engaged in it, knowing that it is inconsistent with their obligations in office and knowing that it would harm the person who is bringing the case forward. So that's the plaintiff. So they had some sort of knowledge. So the state of mind of the chief or councilor, some evidence would have to be put forward about what their state of mind was when they engaged in that conduct. Or the person bringing the case forward would be, in the alternative, allowed to show that the chief or councilor had some awareness that their conduct was unlawful, and they knew that they were somewhat aware that it would be likely to injure the person who's bringing the claim against them. So this is a subjective awareness that the harm to the person bringing the claim against them was a likely consequence of the misconduct or the act that the chief or councilor engaged in. This includes recklessness or willful blindness. Recklessness is where a person is acting in a way that they are being ignorant to the possible consequences, and they're not even thinking about the consequences. They're just acting without thinking and putting no care at all to the person who's could be affected. Willful blindness is where they know there's somebody who could be affected, but they decide not to investigate that any further or think about any further, and they decide to actively, in their own mind, kind of pretend that that's not an issue. The person who is bringing the case against the chief or counselor would also have to show that the chief or counselor owed a duty to them. So that they are a band member, for example, that they had a right not to be damaged or injured by the deliberate abuse of the chief or counselor's power, and that it's the chief or counselor's abuse of that power that caused the actual harm, not that it could have included harm. So, for example, a person can't say, well, that counselor made a decision and I could have been harmed by it. It was reckless, it was unlawful, and it could have hurt me. That wouldn't be enough in a case being brought forward under this misfeasance in public office. The person who's bringing the case forward would have to show that they experienced actual harm. So as a result of the chief or counselor's actions, I actually experienced a real harm as a result of that. And they would need to show that the harm experienced was not too remote from the chief or counselor's conduct. So it couldn't be that the chief or counselor did something and it caused something else to happen, and that thing caused something else to happen, and then that thing caused something else to happen that harmed the person. So it has to be a close relationship between the conduct of the chief or counselor and the harm that the person experienced. The next type of case that a person could potentially bring forward against a chief or counselor to hold them accountable for their actions would be a breach of fiduciary duty. And there's a case in BC, Louis versus Louis, where this particular type of a case was brought forward, and the BC Court of Appeal had some things to say about how it works and clarified a few things. So in the BC Court of Appeal, they said that the two most fundamental and longstanding obligations of fiduciaries, with being the chief or counselor being the fiduciary, is that there's a no conflict rule and a no profit rule. And those rules have been stated lots in different ways. And basically, what they're saying is that the chief or counselor cannot be somebody who is going to benefit from the decision that's being made. So that's the no profit rule. And the no conflict rule would be that, so unless, sorry, let me just regain myself. So the first piece about this is that unless, basically the chief or counselor can't be making a decision where they put themselves into a conflict of interest. So they can't make a decision where they are personally benefiting from the decision that they're making. So that's the two parts, is the no conflict, and then the no profit is the benefit part. So they're making a decision because they're in a conflict in a way that they're going to profit from it. So there is an exception, of course. Sometimes chiefs and counselors have to make decisions that they will benefit from and that they are in a conflict of interest to make that decision. But the benefit that they're going to get is the same as the benefit that all members are going to get from the decision they make. So there's this exception to this no profit rule part of it. Now, if we look at answerability of public officials in the provincial context, there's an act called a Recall and Initiative Act. And basically, that's a provincial law where there's a process in it to remove a member of the Legislative Assembly from their office in between elections. So not having to wait until the next election for them to be removed by vote. Basically, there's a process for a petition, and you have to be a registered voter to bring the petition forward, and you need to collect signatures from other registered voters in your electoral district. So that would be the electoral district that the member of the Legislative Assembly represents. And if the required signature threshold is met, then the member of Legislative Assembly can be removed and a by-election can be held. The signature requirement is that there needs to be more than 40% of the voters who were eligible to vote in that election signing the petition. So it's a very high threshold for this to happen. And to be eligible to sign the petition, you have to be a currently registered voter in that district. So you can't be somebody who was a registered voter at the time the person was elected in, and now you've moved away. And you also have to have been registered at the time of the vote. So there's kind of two pieces about the timing of when you're a registered voter. So this is a process that is not super highly used by people in BC. There's been a couple of instances where this process has been used, but it's very rare. If we take a look at how other First Nations laws address issues of potential misconduct and bad behavior, basically, the first example I have is around Takla Lake First Nation, and they got their own election code in 2015. And in that election code, it sets out grounds for removal. So what would be considered misconduct? It defines misconduct. And a council, it also says that council may remove by BCR if those grounds for removal exist. In addition to this, electors can bring a petition for removal. If electors bring a petition for removal, then there's an appeals authority that looks at it and makes the decision about whether or not the grounds for removal exist. So in the first case, if a council want to remove by BCR, the rest of council are the ones that decide whether grounds for removal exist, and they can make that decision to remove. If it's an elector who brings forward the question about whether grounds for removal exist, they have to do it by petition, and then it's an appeals authority that makes the decision. The second First Nation example I have here is Witset, which got their election code in 2017 here. And again, it sets out grounds for removal. So what is the definition of misconduct? What would trigger a potential removal process? And then it sets out the procedures where either electors or band council can bring petitions for removal to a complaints and appeals board. The Complaints and Appeals Board is appointed by council before each election. So the outgoing council makes an appointment of people to the Complaints and Appeals Board. The board is made up of 2 elders of the band, 2 other members of the band, and 1 individual who has to be familiar with the election process and familiar with legal processes around elections on reserve. The Complaints and Appeals Board holds hearings in accordance with specific rules and procedures that are set out in the election code, and it makes the final decisions around whether the grounds for removal exist and around the outcome. The next example I have here is more recent from Gitga'ala, and they have a 2024 dated election code. And in their election code, it sets out grounds for removal, and it says that council may investigate. So here, for the first time, you see a process for investigation in the example of a First Nations law. And then after the investigation, council can remove by BCR if the investigation finds that grounds for removal occur. They existed. If a person is removed from office by council, then there's an appeal process for the council decision to an independent arbitrator. So this is an independent decision maker who has to meet certain qualifications criteria. They are not an employee of Gitga'ala, they are external to Gitga'ala. The next example I have is from Lac Wallams, and this is a 2019 election code. Again, it sets out grounds for removal. So our grounds for removal and council misconduct discussion occurred in our last meeting. So anybody who's interested in that and they're watching this video would maybe want to go back to that video. Under the Lac Wallams band election law, the band members can file a petition for removal to the electoral officer and to legal counsel, and it has to be signed. Any petition needs to be signed by at least 51% of the members who voted in the last election, and there is a $100 fee for making that petition and bringing it forward. An arbitrator is then appointed to hear and decide whether grounds for removal exist and declare vacancy if necessary. So again, here you see the independent decision maker, kind of like a judge, making the final decision and hearing evidence about what happened. This is different than the election process for Gitga'ala, where they investigate. So it's an investigator is appointed. And again, we'll go back to, I'll come back to the difference between investigation and adjudication, or in this case, they call it arbitration. Those terms get really mixed up by people, and they get used in different ways. In L'Aquilons, again, it says 7 or more band council members can remove by resolution if grounds for removal exist and they follow a fair process set out in the code. So here you have another process where band council can also make the decision to remove, not just an arbitrator who's listening to a petition. Band council can discuss their own issues with regards to potential misconduct and decide to do the removal process themselves. Now we're coming to the Blueberry River Custom Election Bylaw. This was passed in 2017. When I started the presentation for this topic today, I talked about how there was a law that I had helped a First Nation develop, and then that First Nation ended up not having enough people participate in the ratification vote to pass the law. However, it was publicly posted on the internet, and I came across the Blueberry River Custom Election Bylaw, and I saw that it's actually almost the exact law that I drafted for the First Nation I worked with. So this law was created following a similar process to what we're doing with Witset. And in the Blueberry River law, basically it sets out the types of conduct that are subject to disciplinary action, and it also sets out criteria for when a person is no longer eligible to be on council. If there is a situation where a misconduct or eligibility issue arises, then a report gets made to the chief operating officer, and they add that report to the next council meeting agenda. They also advise the person who made the report of the date and time of the council meeting, and they post a copy of the report that was made on their website and in public buildings on their lands. At the council meeting that gets held to discuss the report, the council member who is the subject of that report has to then admit to all or some of the allegations or deny them. So they have to say, here's what I admit to, here's what's true out of what the person making the report says, and here's what's not true. Now, if it has to do, the council member decides we're going to admit to all the allegations that are made against us or against me, then the rest of council is responsible for making a disciplinary order or for making an order that removes them from office. So the discretion is in council to make the decision about what the remedy is going to be. If the council member attends that meeting and they admit to only some of the allegations, then the rest of council has to make a decision about whether to investigate. So they have a private investigator that gets involved, and there are set facts in the factors in the law that council has to consider when they make a decision on whether to initiate an investigation. That includes whether the alleged conduct is serious in nature, whether there would be a significant disciplinary action taken, so a significant remedy granted in the event that the conduct is proven to be true, whether there's been considerable harm caused by that conduct to the First Nation or to an individual member or to all members, whether the alleged conduct involved the use or the threatened use of a weapon or physical violence, harassment, or bullying, whether the council member who the allegation is about has relevant previous disciplinary actions against them, whether the alleged conduct against the council member is criminal in nature, whether there are grounds for believing that the alleged conduct may be continued or repeated, and whether there's a need to protect the integrity of council as a whole. So these are the different things that council decides when a council member has to think about. If a council member admits to only some allegations against them, and now council has to go, okay, well, is it in the best interests of the community for us to initiate an investigation into this? And it's not always in the best interest if there's, for example, an allegation that's quite minor and the type of remedy that would come out of it would be minor. It's not criminal. There's nobody been directly hurt by it. Maybe the councillor did not follow a policy or a procedure properly, for example, but there was nobody directly harmed out of that, or the harm was very minimal. That might not warrant the hiring of an investigator. That can be a very expensive process for a First Nation to have to pay for. So if the investigation is ordered, then the investigator is the person who decides the issue of disciplinary conduct or loss of eligibility. So the investigator collects all of the information and evidence that they wish to do, and then they decide, did misconduct occur? Or they decide, did the council member lose their eligibility to be on council? So this is what happens if only some things are admitted and then an investigation may be ordered. If a council member denies all of the allegations, again, council must decide whether to investigate, thinking about those same factors that I outlined earlier. And again, if an investigation is ordered, then they need to decide whether misconduct occurred or whether the chief or a council member has lost their eligibility to sit on council. When the council is making a disciplinary order or granting a remedy, there's also a set number of factors that they have to consider. So at the end of the day, you see that council makes the final decision on what the remedy is here in this law for all these three circumstances. And they need to consider when they make that remedy, things like whether it's in the best interests of the membership, whether there's a need to deter that council member from current or future similar actions, the nature and gravity of their misconduct, the impact of their misconduct on any victims, whether similar allegations have been proven against them in the past, the number and frequency of those similar proven allegations if they do exist, and whether or not the council member has acknowledged their misconduct is a factor they consider. So if the investigator, I already covered this a little bit, that if the investigator finds that disciplinary conduct did occur, then council makes the disciplinary order against the council member. If the investigator finds that a loss of eligibility to sit on council occurred, then council makes the order that the council member is removed from office because they're not eligible anymore to sit in office, and they give notice to Indigenous Services Canada about that removal and about the vacancy of the seat. If the investigator finds that no disciplinary conduct occurred, or they find that there was no loss of eligibility, then the report to council gets dismissed. There's no remedy. There's no need for there to be council making any kind of an order about it. If the issue is around the loss of confidence, there's a process in the Blueberry River Custom Election Bylaw for situations where there's no misconduct that occurred, but members, for their own reasons, have just lost confidence in this chief or councillor. In that type of circumstance, 60% of electors who've lost their confidence, or 60% who've lost their confidence in the chief or of a family group member, so family group member is like their family group councillors in this case, then they can make their petition to the chief operating officer. They have to have 60% of those people sign the petition though. Then it gets added to the next council meeting. The chief operating officer advises each person who signed the petition of the date and time of the meeting and posts that petition on the website and in public buildings of the First Nation. And then in order for the petition to be to lead to the actual removal of a chief or councillor, each person who signed it needs to make themselves available by phone, in person, or otherwise by electronic means to confirm their signature and confirm their intent to seek removal from office. And that then a council meeting is held after the petitioners all have to validate their signatures on that petition. And if there is a validation of at least 60% of electors saying we want this person removed, then council makes the order to remove them from office and gives ISC a notice about that order and the vacancy from office. And if there are less than 30% of electors who confirm their signatures on the petition, or there's less than 60% who even sign the petition, then the petition gets dismissed and business as usual. Now I want to just touch on some of the different types of remedies that I've seen in First Nations laws for making things right with regards to council misconduct. So these are the types of accountability recommendations and orders that get made. Is an order, for example, that a chief or counselor has to participate in an Indigenous justice process or a traditional ceremony. So something like restorative justice, for example, where they come together with the people who've been harmed by their actions and they have to have a blunt discussion about what they did wrong and how they're going to make it right and make commitments to those people and follow through with those commitments. So that would be that example. Some communities say they want to have the ability to order that chiefs and counselors complete community service hours and give back to community to make up for the misconduct that they did engage in. And some want to make orders that the chief or counselor has to pay monetary compensation, so pay money to somebody for any losses, injury to dignity, or other damage that they've caused as a result of their misconduct. Orders to give a public apology are pretty popular amongst First Nations. And then also declarations that what the person did was wrong and it was misconduct, and orders that they refrain from doing that same type of conduct in the future, or a declaration that what they did was wrong and an order that they have to do something specific to make up for it. So that might be, for example, in a situation where maybe the misconduct was not following a policy properly. And so now they have to go back and actually follow that proper process that's set out in the policy for the decision that they made incorrectly, or they engaged in misconduct by, for example, making a decision without even looking at the policy. That would be an example there. Verbal warnings, written warnings, and suspensions from duties without being paid honoraria are also popular amongst First Nations in their laws around types of remedies that could be granted, and sometimes with or without a public statement being made about the verbal warning or written warning. Removal from office, and then legal action on behalf of the First Nation. So that would be, for example, if the misconduct caused some significant financial harm to the First Nation. Say the council member was writing themselves checks. Say that was it, as an extreme measure of something that could go wrong. Perhaps the order that gets made is that the executive director engaged legal counsel to bring a breach of fiduciary duty action against that chief or counselor on behalf of the First Nation, seeking that they must repay as a remedy through the courts all the money that they had taken from the First Nation. And then there's all sorts of other things that could be included, and that would be up to, in this case, Witset, to make a decision on what they want those remedies to look like. So the next thing I would like to touch on, now that we've seen how other communities work through things and the different types of processes that there could be, is identifying a few of the differences between an investigation process and an adjudication or court-like process. So common aspects of what we see in investigation processes are that there's a request for the investigation, and that in the Blueberry River, for example, would be council requesting the investigation. Could also be that an investigation is mandatory and automatic, but I don't recommend that, because then you could end up expending a lot of band resources on investigations for things that could be very minor allegations of misconduct that could be out of balance compared to the amount of money that it costs for an investigation. Generally, there would be a screening that occurs with regard to the request for investigation, and then somebody has to make the decision to investigate or appoint an investigator. So during the screening process, what you might be asking is, if everything that is set out in this request is true, then would grounds for accountability exist? Does what the person set out in this request for an investigation actually make up misconduct under our law? So if it was true, would it be misconduct? And if it were true and the answer is it wouldn't be misconduct, then you would not appoint the investigator, because even if the person can prove everything they're saying, it's still not misconduct under the law. So the process ends there. And then if an investigator does get appointed, then there's a fact-finding process that the investigator undertakes. They would meet and interview each of the people who are involved in the matter. They might identify and review different types of documents that relate to the issue, emails, written documents, maybe there's photographs or video evidence that they want to review. They would also invite written submissions from people who are involved in what happened and asking them why, for example, should I believe what you said over what this other person said? Because they might have to make findings about credibility and who's telling the truth. So there would be, the fact finding is really open in this case for the investigator to go out and seek out the information that they want. They decide who they want to talk to. They decide what type of information they want to ask for. And they're in control of all the evidence that, they're in control of what type of evidence they ask for. Then after they complete their fact finding, they make some decisions. They say, here's all the evidence that we gathered, and they analyze it to determine what they believe happened. They make a decision about what they believe happened, and they explain why. Why would they, for example, believe what one person said over the other? They have to give their reasons for why they believe that. And after they decide what happened, they would say, okay, do grounds for accountability exist? Was what happened actually misconduct under the law? And they need to set out, and here's why we believe that it was misconduct under the law. Then the investigator could make recommendations to, in the Blueberry River case, they have the recommendation being made to chief and counsel on what type of remedy or corrective measure should be taken with regards to the misconduct. And so here you don't have the investigator making a final decision about what the remedy is. They're just making final decisions about what happened, and they're making final decisions about whether what happened actually was misconduct under the law. So after the investigation process is done, a couple different things could happen. It's possible that you could have it drafted into the law that after the investigation, there's the ability of the person who engaged in the misconduct to enter into an agreed process for making things right. Or you can have that some other body is responsible for making orders that the person who engaged in misconduct must follow, and they must follow through with those orders. Now, if we compare that to an adjudicative process, which is more like a court, you have a complaint or a report being filed, and in that it's going to be setting out who was involved, what happened, when did it happen, and what ground for accountability does the complaint relate to. So what type of misconduct are you saying occurred? And then again, there would still be a screening assessment of the complaint. Generally, there would be a time limit set out in the law for how long somebody has to file a complaint after the events that occurred finished happening, like after the event happened. And then during the screening, somebody at the administrative side of the kind of court process here would again have to ask, if everything that is said in the complaint is true, would it amount to the grounds for accountability? Would it be counsel misconduct under the law if we accept that everything they're alleging happened is true? And if the answer is no, then that would be the end of it. And if the answer is yes, then there would be a notice that goes out. And this is about the right to know the case against you as a chief or counselor. So the notice would go to the chief or counselor who is the subject of the complaint, including the details of all the allegations about what they allegedly did. And then there's also a right to be heard, that the chief or counselor who is the subject of the complaint has to be provided an opportunity to give their version of events about what happened and set out and explain why what happened is or is not counsel misconduct. So this is the opportunity to respond. Then sometimes in a court type like process, there'll be a disclosure process. So this is also about the right to know the case against you as the chief or counselor. So this is where any type of document and any witness that the person who brings the complaint wants to rely on and put forward to the adjudicator in the adjudication hearing wishes to use and rely on, they have to share all of that with the chief or counselor who they've made the complaint about in advance of the hearing. So the chief or counselor knows all those details and has an opportunity to plan their response and plan how they're going to defend themselves in that court-like process. Sometimes in this court-like process, there will be a process where the chief or counselor can apply for the complaint to be dismissed without a hearing. Generally, if it has no reasonable prospect of success, so they can say, even if everything that this person says is true, it's not misconduct, so we don't think it should go to a hearing. Or they can claim, for example, that it was made in bad faith. They are just mad at me because we're getting a divorce. This isn't even true. They filed this because I didn't agree to their access to the children. Those are types of examples of where maybe a bad faith request for early dismissal might be made. And then there's a hearing conducted. So you see the difference here with the hearing and the investigation being that when there's a hearing, it's the person who made the complaint and the chief or counselor who is the subject of the complaint who are responsible for deciding who they're going to put forward as a witness. They're responsible for deciding what evidence they want to put before the decision maker. The decision maker takes somewhat of a hands-off approach to this. They may ask questions, and during a pre-hearing case conference, for example, ask the parties, who do you have that can speak to this part of what you say in your complaint? Because I see you're going to provide evidence, but that the complaint you make actually has to have to do with something that you weren't present for. So how are you planning to prove that? And put those things to the person raising the complaint at the pre-hearing conference. And that's there's some ways that the person who's the adjudicator is involved in the process before it gets to the stage of the hearing to help guide the parties to make sure that they're getting the best evidence possible put before them. But they're not in charge of making those decisions about what evidence comes forward. Once it gets to a hearing, they take the evidence that gets presented, and that's it. So there's a presentation of evidence by both sides, the person who brought the complaint and also by the person who is defending themselves against it, being the chief or counselor. And if this includes if there's proof of losses, for example, the person who raised the complaint is trying to seek a monetary remedy, they want an order for compensation to be given by the adjudicator, then they have to also prove all the monetary losses that they've experienced, prove how it's connected to the events that happened. So there's different types of evidence that might be helpful for that they are responsible to be putting forward. The right to be heard, so there's cross-examination as well. So each person gets an opportunity to challenge the evidence of the other person. And they also each get opportunities to make legal arguments and submissions to the adjudicator. And then at the end of the day, the adjudicator makes the final decision. And of course, the parties have a right to the reasons for decision. That's part of the procedural fairness that has to be built into the process. So the adjudicator has to write that decision up, or at very least orally explain it and give all the reasons for why they accepted one person's testimony over the other, for how did they make their decision about what actually happened? How did they decide that what happened was actually misconduct? And then, of course, what the remedy is and how did they decide that that was an appropriate remedy? So adjudicative processes, you can see, are much more involved. Some sample considerations that could be used when adjudicators are making decisions around what the remedy will be. It includes the community needs, so the need to ensure members' confidence in the integrity of counsel, the fiduciary duties of counsel having to act in the members' best interests at all times, levels of impact on the First Nation, what type of a remedy might deter that person from doing it again, so that's specific deterrence, and what type of a remedy might deter all chief and counselors into the foreseeable future from doing that type of thing, which would be a general deterrence. And then also looking at fairness to the individual council member. So was the individual council member voluntarily apologizing and acknowledging their actions already at any part of the process? And how serious, making sure that the seriousness of the order that they make against that council member matches the seriousness of the mishap, that the type of misconduct that occurred. So making sure that there's a balance there. And then also considering history of their contributions to community and their role in council, and just trying to make sure that there's a balance there, and any history of similar mishaps. These are some examples of considerations that can be built into the law. The community can decide what considerations they want that to include, though. The next thing is looking at the Wet'suwet'en legal traditions and then having some discussion around what Witset wants to see in its custom election code around the process and decision making and types of remedies that should be included in it for council accountability. So let's come to the Wet'suwet'en legal traditions. I reviewed some of the literature of our Wet'suwet'en hereditary chiefs and things that happened through the Dalgamute trial and just different books that are out there. So this comes from the Ways of Our Ancestors book. And in that, they talk about the feast system being used to settle arguments and maintain peaceful relations and to resolve conflict of either an internal or external nature between the between nations, neighboring nations. Some of the different types of feasts that they talk about in the Ways of Our Ancestors book is shame feasts, and it's described in the book as a way of wiping away of the blood. And shame feasts being held to make up for mistakes or misconduct that occurred during a previous feast or an event in the community, and being used to resolve arguments or situations where a person has been publicly embarrassed or humiliated. The next is Kaneyekli. Oh, I know Ron's going to be saying something about how I pronounce that. Which is an individually hosted shame feast. So this is where individuals are accountable to the hereditary chiefs, to persons offended, and to the whole community. So this is about who's hosting the feast. And then they also talk about Ludilsas. They're wiping each other, or they're whipping of each other. This is where two people hold a shame feast because they're in a conflict, and they each hold a shame feast. So neither of them is willing to accept blame for a problem that occurred, and they're each trying to outdo the other to save face in this type of a shame feast. So the reason I bring up these Wet'suwet'en legal traditions is to just think about how do we incorporate the Wet'suwet'en ways of being into any process that Witset decides to have in its election law for council misconduct. How can we follow the principles of what underlies a shame feast? Or maybe a shame feast type style approach is what you want to have included. And maybe the shame feast is hosted by, maybe the shame feast is one of the remedies that can be ordered. And then if the council member doesn't hold that shame feast, then maybe that's when they get removed from council because they don't uphold the remedy. So this could be also built in the form of the remedy part of the process that gets engaged. Now, something that I came across and to hang on to these words, which is Johnny David's Dalgamute evidence, and the page number is at the bottom there. So when Johnny David gave his evidence at the Dalgamute trial, he recalled an example of a shame feast, but he did not attend it. So this is just an example that he shared about that. And he said, Kaniyet, that means shame. And Wistes, which means big hand, Loris Mitchell of the Laxilyu clan, he said he recalls he was hit by Pat Namox's son. And he said that all of the Laxilyu helped Wistes put on a feast, and all clans were invited to that feast. Johnny David was not at the feast himself, but says the people who hit Wistes should have been there to listen to what was said. He talked about Nanaletni. He said they were denied access to the territory they snuck around on, and sneaking around can mean many things. He said their behavior would be addressed at a feast. So these are people sneaking around in the territory. So this is thinking about sneaky conduct of somebody, right? Their behavior would be addressed at a feast, and the process was known as Sonana Dinletli, meaning to sit down properly, he said. And during that process, he said the head chiefs would all speak to the people who are sneaking around, and everyone would be present there. And then if the person did not listen to them, they would be banished. So if people who are sneaking around didn't listen to what the head chiefs had to say, they experienced banishment. So you could see that there's maybe some sort of an analogy that could be drawn between some of the stories here of Johnny David and just thinking about, how this might fit into a custom election law. If there's misconduct, sneaking around, doing things against how things are supposed to be done, right? Then maybe there would be a feast and the rest of chief and council would attend, and the rest of chief and council would talk to them about their behavior. And they would have to sit there and they would have to listen to it. And if they didn't agree to come and listen to it all, and maybe even members would get to come in and talk about how'd that impact them. And if the chief or counselor who engaged in the misconduct said, no, I'm not going to that, I'm not attending that, I'm not subjecting myself to that, maybe it leads to them being removed because they failed to participate in the process. This is kind of an analogous way that this might fit in. So then I'd ask everyone to think about other Wet'suwet'en considerations. What are other stories from long ago or songs that you know about our history, other parts of our Wet'suwet'en language, other laws that exist or oral traditions that exist that you could think of that teach us about how our leaders, so our chiefs, are answerable to us? And how can that be fit into a Wet'suwet'en a Witset process that's grounded in Wet'suwet'en ways of being that we develop for dealing with council misconduct? So this is where I ask people to have a discussion around what are those stories that you could think of? What are those songs that come to mind when you're looking at how our leaders are answerable to us as Witset people? If you were looking at it in our traditional way, it's how are our hereditary chiefs, how are they answerable to us as members of their house group, for example? What laws do we have around that? What history of songs or stories do we have around that? And you can see Johnny David has his examples of the shame feasts, right? And then the next thing to think about and talk about would be, having considered how other people deal with things in other First Nations, how things are dealt with by the provincial government, how things are currently being dealt with under the Indian Act, which is basically that they're not being dealt with. And, thinking about all this stuff and thinking about Wet'suwet'en legal traditions, how do we want the Witset accountability process to look? Who should be the person who is allowed to make a request to initiate an accountability process? If a council member does not admit to allegations against them, what happens next? So they're saying, I don't admit to doing that. Who decides whether what the report or complaint says they engaged in, what actions the community members alleging against them is true? Who makes that decision? Is that an investigator? Is that an adjudicator? Who goes through that process? Who's qualified to do that? Who can make sure that process is fair? Who can make sure that who's a person that has the ability to provide logical reasons after they make that decision and explain themselves? What types of skills will that person need to have? These are the types of things to think about. And then after a council member admits to conduct that is subject to disciplinary action, so they've admitted to some sort of a misconduct, or the person who's deciding whether the misconduct occurred has made that decision and they've said, yes, it did occur, who then decides the appropriate remedy to make things better? This doesn't have to be the same person who decides whether misconduct occurred or who makes a decision about what actually happened. This is where you can think, maybe this is where we make use of our elders. Maybe this is where we have our community-based process. So this is where you look at that piece there. And maybe there's some sort of a feast type approach to things that could be taken here. And then after a council member admits to misconduct, or they are found guilty of some sort of misconduct by an investigator or an adjudicator, what are the types of remedies that should be made available to deal with that? What types of orders should the people who decide the appropriate remedy be allowed to make? And should we create limits to that?